GNH or F also?
Not F, my lord.
Not F. So GNH, what is your, how do you prove that juniors to you are retained?
My only thing is that once we are already out of the service, only thing is that the work which we were doing,
Is
there are
continued.
still people who are doing it.
That are they
Yes,
seniors
their
to you?
officers themselves have categorically admitted in the deposition of that Mr. Machar.
Page 31.
Yes, as he has said that seniority list રજૂ કરી શકું તેમ નથી. Sir, when we are already out of the service, can only find out that the work is going on and somebody is working at our place. When
Only
place
thing the labor
31
court has
is
not even
40,
appreciated their statement at exhibit 10, that table.
for the time being, my lords, may kindly turn to page number 31 with charge from page
Para
number
13 and 14.
14, yes, ma'am. વડી કચેરી દ્વારા seniority list હું રજૂ કરી શકું નહીં. He being the authority, my lord, is still before the court seeing that.
What was your case that juniors were retained?
Yes, this is what was found out at relevant point of time, that those people, એ લોકોએ what they have stated is વડી કચેરીથી આવે છે. Nothing else was by them also.
કઈ
produced
જગ્યાએ
on
કામ
that.
કરતા હતા મને ખબર નથી.
Yes.
અમો અરજદારોથી સિનિયર છે કે જુનિયર છે મને ખબર નથી.
Sir.
Your deposition is also.
But we were categorically at that time also explicitly clear કે આટલા લોકો સાહેબ are working on our case.
Now that is produced on record at page 33. Admittedly, not seen junior.
There is only one person that who is senior, that
अरे क्या है? Page 33.
6 number. that
See page
Bajania.
33. Page 33. Bajania is 86. Others are 88, 85, 93, 87, 94, 99.
Those are the people, my lords, who they
I
said
will,
that they are
at
senior.
best I can send it back that this exhibit 10 must be reconsidered by the labor court. And record a specific finding that there is violation of GNH in light of this.
Because otherwise,
I
my
can
lords,
only postpone the state funeral for your workmen for some time.
only thing is that they have worked substantially.
Correct, but there is no
And-
finding
and-
as to 25 G.
No question of reinstatement. or-
There will be no question
Yes.
of reinstatement even otherwise in the first part.
Yes, only thing is that it is not the case that they also have time FSC produced everything on record from their side before the labor court that.
Correct.
So
You are
the
right.
only thing is
That is
that.
why I can only give you a second chance to go back.
Because if my lords may for the time being see 2599, the my,
2599.
yes. Which is wherein I have,
Page. 259. Yes, 259.
where in my petition itself, my lords, I have categorically mentioned in para 4, my lords.
Para 4, page
Yes.
2.
Page 2,
Submit
page
that
overleaf, page
out of
3, that petitioner number
work
1.
is permanent nature.
Yes, petitioner number 1, my lords, he has not proper employment and he could hardly on 200 to 250. only.
Correct, that is for your back wages.
In case of number 2, my lords, it was clearly stated by.
It is
Gurava
again
that
back
he
wages.
is-
You are only addressing the second issue. First issue of reinstatement.
Well, reinstatement, I am bound to only with the ground that it was not their case that there is no work and there is nobody, nobody is required by them.
This exhibit 10 heard Mr. Bhargav Pandya. I'll send it back to the labor court.
Please, ma'am.
Reconsider exhibit 10 and pass a fresh out
Please, ma'am.
within some time bound time. 2006 awards.
Please, ma'am.
Heard Mr. Bhargav. Sit down.
Only request is that some time limit may be.
Yes, yes.
Because otherwise the another.
Now only
one
this
would
has to
also-
on this stage only.
Please,
Yes, sir. Both matters. 251,812 and 2599
2599.
of 2008.
And
2600.
5812, 813 and a 2599.
There is another also 2600.
2600 is
Baby.
Bebe matter.
Yes.
2600 મંગાઈ લેશું. 2600 હશે જ.
That would be that one-page petition, so it
Acha,
would be
one page.
after, yes.
आમાં જશે. One page. छे one page. हाँ,
It is a transfer brief, so
हाँ. Heard Mr. Bhargav Pandya for the petitioners of special civil application number 25812 and 25813 of 2007. Full stop. These petitions are preferred by the employer, Gujarat Water Supply and Sewerage Board.
Please, ma'am.
Gujarat Water Supply and Sewerage Board against the award, common award passed in reference 58 of 2006, reference into bracket LCS 58 of 2006
51 of 2006.
and 51 of 2006. So by the award dated 12th of March 2007, the Labour Court Surendranagar has directed the board to reinstate the workmen without back wages. Full stop. Paragraph. Agreed by the aforesaid awards in as much as it denied back wages. The respondent workmen have also preferred special civil application numbers 2599 and 2600 of 2008. All these petitions are heard together and disposed of by this common order. Paragraph. Facts in brief would indicate that it was the case of the workmen. Petition the employer nation. It is the case of the workmen before the Labour Court that they were working with the Water Supply and Sewerage Board for the periods from 7/12/1994 to 13/9/05 and 14/2/1995 to 13/9/05. In the respective references. It was their case that their termination was in violation of the provisions of section 25 capital F, 25 capital G and 25 capital H of the Industrial Disputes Act. The Labour Court, based on the evidence produced on record, came to the conclusion that since the workmen had in their deposition named 4 workmen, Mari Bhai, Bajania Bhai, Lal Bhai and 1 Darbar, and the other 9 to 10 workmen who were continued in service despite even after the retrenchment of the petition of the workmen concerned in the present petitions, the Labour Court held that there was violation of the provisions of section 25 capital G of the Act. Provision of. The Labour Court further held that From the cross-examination of the employer, it had come on record that the seniority list was not maintained and the employer was not certain of the list being maintained, and also that the work was being continued by engaging surplus staff. On this count, the Labour Code also held that there was violation of the provisions of Section 25 capital H of the Act and therefore awarded reinstatement without back wages. Para Mr. Bhargav Pandya, learned counsel appearing for the petitioner, would submit that admittedly the Labour Court had found that there was no violation of Section 25 capital F of the Industrial Disputes Act, as the compensation was paid and was accepted by the workmen concerned. He would draw the court's attention to the deposition of the workmen at Exhibit 10. He would submit that it was their case that they were part-time workers and after their termination, they intermittently worked as laborers and would get some amount. Relying on the additional affidavit filed by them, he would submit that it was their clear admission that they had accepted the compensation, however under protest. Mr. Pandya would further submit that in their affidavit supporting their deposition, though they had said that about 9 to 10 workmen, including the names referred to in the earlier part of this order, were working. However, they were not sure as to whether these 9 people who were retained were either senior or junior to the workmen. The employer was examined at Exhibit 27, namely one Harshad Kunj Vasantarai Machar. Reading his deposition, it was admitted that the workmen had accepted the amount of retrenchment compensation. As far as seniority is concerned, though the deposition indicated that new persons were engaged, the staff of the surplus staff was used for continuing the work. Mr. Pandya would further submit that the Labour Court failed to appreciate that along with the affidavit filed at Exhibit 10 and the affidavit at Exhibit 27, the board had produced documentary evidence which stated that the laborers named by the workmen and the others were senior to the workmen, and therefore there was no violation of the provisions of Section 25G and H of the Act. You would submit that essentially the burden was on the workmen, which was not discharged, to prove the violation. In support of his submission, Mr. Pandya would rely on a decision of this court. In the case of Ranjit Natwarlal Chauhan versus Morbi Nagar Palika, reported in 11-2 GLR 17832. Here છે. Citation. He would refer to paras 11 and 12, 12 and 13 of the decision. Paragraph. Ms. Niyati Vaishnav Learned Counsel appearing for the workmen in all the four petitions would support the award of the Labour Court, holding that there was violation of the provisions of section 25 capital G and H of the Act. She would submit that a categorical positive statement was made that 9 to 10 persons were continued in service after the retrenchment of the present workmen. Full stop. That even the employer had admitted that no seniority list was produced, comma, that 32 workmen were carrying out the work which was being rendered through the surplus staff, and therefore no fault can be found with the award in as much as the finding of 25 capital G and capital H was violated. Para. As far as her petitions challenging denial of back wages is concerned, she would submit that it was only intermittently that the workmen would have earned rupees 200 to 300 rupees. But in the subsequent,
Only one
only
person
one
has-
work-
another has
Huh.
not earned anything. for-
only one workman had in
Yeah.
his deposition, namely Tevatia,
Yes.
had
Dilip-
stated,
Yes.
Dilip Bhai Tevatia, had stated that he was earning so and so. 250 from. The other workman
Has not.
was not earning anything. And even otherwise, in the additional affidavit, they had clearly stated that they were in search of work, but they were not getting any work. In the teeth of these submissions, comma, outright denial of back wages by the labor court was unjust. Paragraph.
Those judgments of Deepali Gundu and I have.
Ha,
given-
Deepali Gundu, para
Yes,
38.
But Tapash Kumar also. which
Na,
says
Deepali
that
Gundu is the best. Para 38.
Every other judgment has also followed.
Deepali Gundu. She would rely on a
Jasmeet
decision
Singh.
in the case of Sarvase. So Deepali Gundu Sarvase. Okay, it's
Yes.
Ah. Para 38 of the decision, and submit that when there is an award directing reinstatement, comma, back wages must follow unless back wages is a normal rule. Once the award of reinstatement has been passed. She would rely on para 38 of the decision, which reads as under 38.1 check over 38.7. Para having considered the submissions made by the learned advocates for the respective parties, two things need to be noted. Basically,
Yes, there is another Jasmeet Singh also 2015, which follows in fact Deepali Gundu.
this is the best judgment.
Please, Jaili.
Deepali Gundu is Bible.
Please, Jaili.
Following factors One, admittedly, the case of the respondent, the case of the workman, that there was violation of the provisions of section 25 capital F of the Industrial Disputes Act has not been accepted by the Labor Court. In view of the evidence which has come on record that the workman had accepted the compensation, albeit under protest. Two, considering the violation of the provisions of section 25 capital G, 25 capital H of the Industrial Disputes Act, shall be retained by the obvious. Sometimes they ask, yes, Mr. Bhatt.
Serial number 79. While another friend says my lord, that they have signed my lord, original copy
Of the
of the
pension
order.
paper.
Yes, but I say my lord that this may be kept on 20. But till
No, you have not received.
yes, that's what I'm saying, my lord. This may be kept on first or second, my lord, second.
9.
I leave it to
You
the
are not here. 8.
8th
Art-
or 9th.
8th or 9th.
Please, my lord.
Huh? Draft amendment. That day we will see. Because your matter is all, the whole matter is called. You ask for draft amendment, I call the whole matter.
સાહેબ સોરી આપણે રિટેન આપે લખાવ્યું એના બદલે નાવ ઓનવર્ડ સ્ટોપ ખાલી સાહેબ અત્યારે પાછું નથી દીધું જેટલું અપાઈ ગયું છે વાંધો
Ah, 17B need not be paid
But